that is absurd, ridiculous, and profoundly wrong. And I helped when I was a member of the Scottish Parliament, an experience I didn't largely enjoy. But when I was a member of the Scottish Parliament, I helped to rewrite the law of Scotland in this regard.
Adam Tompkins is an academic and a politician. He is the John Miller Professor of Public Law at the University of Glasgow, and he was a member of the Scottish Parliament from 2016 to 2021. He's been a constitutional advisor to the House of Lords and to the Scotland Office, and he's also a free speech advocate and the author of 7 books, including his most recent book on the law of speaking freely. So, Adam Tompkins, thank you for joining me today.
Thank you for having me.
What is the biggest threat to free speech in our society today?
Uh, um, well, that's a huge question. I think we are. I think each other. John Stuart Mill said in his great essay on liberty in 1859 that the greatest threat to freedom of speech was social tyranny or social censure. Now that is not the only threat to free speech, but it is a threat to free speech in the West generally, perhaps in the Anglosphere specifically, that is becoming more prominent, not less. And that's a very big change in my professional lifetime. When I first started thinking about freedom of speech, when I was an undergraduate student in the very late 1980s, early 1990s, the biggest threat to free speech was authoritarian government. An authoritarian government that, for example, to use just the UK as an instance, where the Thatcher government chased Peter Wright and his publishers around the world's court, trying to suppress copies of his memoir Spycatcher, which led
I,
to some
I,
some
I
some very
remember
interesting litigation.
I remember buying a surreptitious copy of that by a guy who came to my front door looking each way and then handing me the book for a £20 note, which was apparently illegal at the time, but I
Yes,
still did
I
it on
got
my
my
own.
illegal copy at Camden Market when I was a student. I got on the bus from where I was an undergraduate and went to London, and because I knew that there were copies being sold out of cardboard boxes in Camden Market, and I bought a copy, read it on the bus on the way home, and which I hadn't bothered because it's got nothing very interesting in it.
Well, I
Um,
was so
but there
interested
we
to
are.
see how.
So there, it is still, of course, the case that authoritarian government is a threat to freedom of speech, not just in authoritarian regimes such as Iran or Afghanistan or many others, but also here in the West. But increasingly, those of us who are concerned about freedom of speech in places like Britain and America are concerned about social censure and social tyranny, as well as the authoritarian power of the state.
America is particularly concerned about the lack of free speech in Europe and in this country in particular, and has warned Keir Starmer and others of the way in which we're progressing along a particular route. I mean, what do you make of
Yeah,
things like the Online Safety Act, for example?
I'm not. So yeah, I mean, I've read what Vice President JD Vance has said about
Yeah.
this in various conferences, including the Munich Security Conference last year. I'm completely unpersuaded that JD Vance is a champion of free speech, right? I mean, I think that the Trump administration, including the president himself and the vice president, are quite good at attacking speech that they disagree with, quite good at attacking places where speech that they disagree with is free, including universities in the United States, including a number of universities in the United States. So I'm very, very nervous indeed about the idea that JD Vance is in any sense a kind of impartial spectator when it comes to, scrutinizing freedom of expression on this side of the Atlantic. But that said, it is of course true and has for a very long time now been true that the constitutional law of the United States protects expression as free in ways that are not replicated in European human rights law or indeed under the old English common law. And we can have a disagreement or an argument about or conversation about whether who gets this closer to being right. Do we think that the sort of unlicensed corporate spending in election campaigns in the United States that is protected under the rubric of freedom of expression is an appropriate thing to do with free speech law and so on and so forth. So, in my book on the law of speaking freely, I compare three jurisdictions in particular. I compare the United States, the United Kingdom, and the case law of the ECHR under Article 10 of the European Convention. And I'm more interested, I suppose, in the areas where those jurisdictions disagree with each other than I am where they agree. But the disagreements are probably at the margins. I mean, all three of those jurisdictions are jurisdictions that are deeply committed to ideas of freedom of expression, including the United Kingdom, notwithstanding what the Vice President has said of late.
Well, let me give you one particular case then. What about Ofcom, who is at present pursuing an American company called 4chan with daily fines because they have a free speech open platform based entirely in America, nothing to do with this country, but they seek to be able to fine, or they're trying to fine that company for breaking UK rules.
I don't know anything about the specifics of the case, but I do know quite a lot about Ofcom. And Ofcom are an extraordinary regulator. I've got a chapter in my book about broadcasting, and I've got another chapter in my book about the regulation of the internet. And let's just start with broadcasting, because Ofcom have been a broadcasting regulator for a lot longer than they've been the regulator of the internet or the UK's regulator of aspects of the internet. Now, one of the things that the Brits like to tell themselves, we like to tell ourselves about freedom of expression is that it is a British idea. It's not. And that the United Kingdom has protected freedom of expression for an extraordinarily long time and in an extraordinarily robust way because we have an unlicensed press. And it is true that we have had an unlicensed press relative to most continental European countries for a very long time. In the 18th century, there is no doubt that the press in England in particular was freer than the press in, let's say, France or any of the countries that were subject to the Index of Prohibited Books, for example, which was promulgated regularly by the Vatican all the way up until 1966,
John
which is
Wilkes
hard to
and Co.
believe.
Yeah,
Sorry?
John Wilkes and Co.
Absolutely.
Mm.
But we have never taken our commitment to an unlicensed press and applied that commitment to other areas of the media. So we have, I think, ridiculously over-licensed broadcast. And you can understand why that was important at the dawn of broadcasting technology, because you and I, Philip, are old enough to remember the time when you switched on the radio by tuning a dial to a particular station, and if you couldn't get a clear if you couldn't get your wireless or you couldn't get your radio clearly to attach to that frequency, all you would hear is interference.
Mm.
And so it was necessary for anybody to be able to listen clearly to anything on the radio that the spectrum was licensed so that only one person could broadcast at any one time on any particular frequency. Otherwise, listeners wouldn't be able to hear anything at all. That was a perfectly good, sound justification for really quite strenuous licensing of the broadcast frequencies. But we haven't been broadcasting in that way for decades. We use now digital services for broadcasting, and yet the architecture of our licensing regime for radio and television has not changed. It has changed in the United States. In the United States, in the 1990s, the Supreme Court recognized that their equivalent of Ofcom, the Federal Communications Commission, the FCC, no longer needed in the public interest to license television and radio broadcasts in the way that they had between the 1950s and the 1990s. And we haven't made the like adjustment here in the UK at all. We still have in the UK, even now, extraordinarily restrictive rules that apply to broadcast, which would never apply to the press. And there's no justification for this divergence any longer, even if there was a technological justification for it in the past. Now, what's happened much more recently with regard to Ofcom, because of the passing of the Online Safety Act in 2023, is that Ofcom have become the regulator not just for TV and radio, but also for social media platforms and search engines on the internet. And the regulation of these platforms is nothing like as strenuous as the regulation of TV and radio, but it's much more strenuous than the licensing and regulation of the press and indeed of the publishing industry more generally in the United Kingdom. And this is beginning to worry Americans because American broadcasters may make programs which are available for broadcast in the United Kingdom, but then they don't actually broadcast very much in the United Kingdom. Most American broadcasters are interested in broadcasting in America, so they've never historically worried too much about the way in which on this side of the Atlantic we overregulate broadcast, but they are increasingly worried about the divergence between what the UK and indeed the EU are doing in their Digital Services Act with regard to the licensing of, well, not quite the licensing, but the regulation of social media and search engines in comparison with the freedom of expression which those platforms still enjoy in the United States, albeit that freedom of expression is currently being challenged in a really important case in Los Angeles.
There's a big problem though, as a mismatch, because the internet is worldwide. You put a video on YouTube and anyone can receive it anywhere around the world, but laws are fixed within the boundaries of the nation state. So is Ofcom right to try to regulate broadcasters or people who put stuff up in different countries?
Well, it's not quite as simple as that, though, is it? Because the World Wide Web is not worldwide, and countries do have, and they do indeed exercise the power to switch off access to services within their territories. I don't know what the truth of this is, but it is claimed that Wikipedia, for example, the world's online encyclopedia is available only in, is it three-quarters of the world's countries or something like that? I don't know what the statistic is off the top of my head, but we all know that there are there is a huge range of internet services which we are able freely to enjoy in Europe and indeed in North America, which are unavailable in Iran, and not because people don't have computers, but because people don't have access to the same services through their computers that we do, to say nothing of China or
But the question is
Russia.
though, should we become the kind of country which cuts off parts of the internet because we don't agree with what it's saying?
So my view about this is, I started with John Stuart Mill, and I'm going to go back to John Stuart Mill, right? My view is, I take a, I, I'm a, if you wanted to put a label on me, I'm a kind of sort of classical liberal when it comes to thinking about freedom of speech. And one of the things that means is that our speech should be free. That's the starting point. That's the principle. Our speech should be free, and that restrictions on our speech should be permitted in our legal arrangements only when those restrictions are necessary in the public interest. And they are necessary in the public interest when they are necessary in order to meet an identifiable harm that our speech is causing. So
That's
I
what
am
John
not a
Mill.
free speech. I'm absolutely not a free speech absolutist. I mean, I believe profoundly and deeply in freedom of expression. But there are, there is a vanishingly small number of, I have to say, completely irrelevant commentators who don't accept that there should be some legitimate restrictions on speech. Even in the case law of the United States Supreme Court, there are forms of speech which are not protected under the First Amendment.
John
So
Stuart Mill, I mean, his famous principle of the harm principle, I think he specifically excluded speech as being a form of harm. I mean, there
no,
are
he
many
didn't.
people who
No, 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 he didn't. I mean, that his harm principle appears in a chapter of On Liberty called Freedom of Thought and Discussion. And John Stuart Mill was absolutely of the view that there could be restrictions, legitimate restrictions on speech. And he gave us the example, people talking angrily about the price of corn outside a corn dealer's house.
yes, yeah.
So no, what John Stuart Mill did not do is identify what the harms are which speech can cause, right? So that's where I was coming to. So we have the Online Safety Act in the United Kingdom, rightly or wrongly, because governments of both major political persuasions, Conservative and Labour, have taken the view that there are harms which are caused by online speech, which are greater than the harms which are caused by speech in books and pamphlets and newspapers, or in the press generally. There are harms to children, in particular, and there are harms also to vulnerable adults. And because those harms exist, there needs to be bespoke statutory regulation to combat them. And that's what the Online Safety Act is trying to do. It's incredibly complicated. It's a very difficult piece of legislation to understand. And moreover, it has generated a huge volume of of regulatory guidance and rules that Ofcom has been publishing ever since the OSA came into force in 2023. More than 2,000 pages of consultation documentation has been published by Ofcom about its new powers under the Online Safety Act in the last 2 years alone. So one of the problems with this is accessibility, right? I mean, the law should be simple and clear and accessible, and this law isn't any of those things, right? And that's a very significant problem. The
Can
other,
I bring you? Yeah, go on.
but what the real political harm? I mean, I have to say, I don't have any problem with a legal regime that is designed to combat um, accessibility of child pornographic images on the internet, for example. That's where the OSA, in large measure, came from. It came partly from fears about legitimate fears about child protection, and also it came from fears within the Home Office about the criminal use of the internet, not just by terrorists, but by other, very highly organized criminal gangs. And again, there is no plausible argument, it seems to me, that even a passionate free speech campaigner wouldn't want to see restrictions on speech when that speech is child pornographic or is terrorist in intent or effect. The
I think this
worry
is
with the
where
OSA, the worry with the OSA though is, and this is a well-worn cliche, but I'm going to use it anyway. The worry is that it's the thin end of the wedge. And if we look at the debates which are currently going on in Parliament, in not yet in the chamber, but in select committees, there are a number of select committees that are agitating for much greater power to be conferred by Parliament on Ofcom to regulate not just the evils that we've already identified, child pornography and terrorism, but much more difficult to regulate matters such as disinformation. And the inspiration for this was with the riots following the Southport murders in the summer of 2024, when it was completely wrongly, but very quickly all over the internet, alleged that the perpetrator of those horrendous crimes was an illegal asylum seeker. And that led to quite serious race riots, anti-immigrant race riots in large parts of England and Northern Ireland. When you have very serious public disorder, and those riots were very serious public disorder, being caused, not just contributed to, but caused by lies that are being spread on the internet, then you could say that that is a million harm that needs to be responded to in regulation. The difficulty, of course, is that capturing precisely and legally what you mean by disinformation and attaching liability to that, either on the part of the people who are posting the disinformation online, or indeed liability on the platforms that are carrying those posts, is incredibly difficult. And this is where we have to be really, really careful.
this of course raises the question of the case of Lucy Connolly, who was given
Yeah.
a 32-month sentence for posting something online, which I think she said, if they burn the houses down, I don't care. Did you think that was a fair result or appropriate in the context of what you're talking about?
Um, I was quite surprised that the Court of Appeal upheld the length of sentence. I don't think there's any problem with her conviction. I mean, she's not a free speech martyr. What she posted was horrible. And it has quite clearly been criminal to post the sort of thing that she posted since that offence was first created in 1965. This is not a new offence. Right, stirring up racial hatred is not a new offence. We've had that offence on the statute book, I think, more or less unamended since 1965. It was consolidated in 1986 in legislation passed when the Margaret Thatcher government was still in power. And it's been used many times in many different sorts of instances. And yeah, I mean, stirring up racial hatred is a serious criminal offence. And there's no doubt in my mind, whatever, that she committed it. Whether a 31-month sentence is appropriate to attach to a tweet in those circumstances is a different question. But it went to the Court of Appeal, and the Court of Appeal unanimously, ruled, having looked at it very carefully and closely, that the sentence was appropriate in the circumstances. Now, I'm not a sentencing expert. I have to say that as a citizen, the length of the sentence surprised me, but the conviction did not, and I don't accept at all. Neither does Jonathan Sumption, for example, the recently retired Supreme Court Justice, accept at all that Lucy Connolly was any sort of free speech martyr.
I spoke to Jonathan Sumption about this very issue, and you're quite right. He said it was fair as far as he was concerned.
Yeah.
I never did take that view, and I took the view simply because when you look at the words precisely as to what she said, and when you look at the context of what she said, the context is that she suffered a loss of a child herself, and had an emotional uh, attachment to that kind of event. But as far as I can see, her statement was a hypothetical. If they were burnt down, then I wouldn't cry about it. It's the kind of emphasis. It wasn't go and burn them down, and I'm going to incite that. But that was my view on that. But can I bring you back to the fundamental principle of harm here? Because, like you, I'm a great fan of John Stuart Mill and his harm principle. I think that no one could easily disagree with the idea that if something causes harm, then you should legislate against it. And you've mentioned child pornography and other things which clearly will cause harm. But what about the way in which the law has been particularly interpreted by the College of Policing and such like, to indicate that if someone feels that they have been harmed, in other words, it's a subjective test. If they feel they've been harmed, then they have been harmed, and therefore some steps should be taken, rather than having an objective test of harm.
Yeah, that is absurd, ridiculous, and profoundly wrong. And I helped when I was a member of the Scottish Parliament, an experience I didn't largely enjoy. But when I was a member of the Scottish Parliament, I helped to rewrite the law of Scotland in this regard. And one of the things that we did in the Scottish Parliament when we rewrote the law of Scotland in this regard was we made it absolutely clear that this is not a subjective test, but is an objective one in Scots law. And it's one of the ways in which Scots law is now superior to English law in capturing this much more accurately. So look, but the core of the issue is this. I do not have the right to use my fists to threaten or abuse you or anyone else. And I don't think I should have the right to use my voice or my words to threaten or abuse anyone else either. But there is, I think, the world of difference between threatening and abusive on the one hand, and something which is, as it were, merely offensive or disturbing or shocking or disagreeable on the other hand. If I say something which to you is offensive or disagreeable, then what you should do is you use your words to explain to me and indeed to anyone else who's listening why what I have just said is wrong or disagreeable or whatever it might be, or even offensive. So, in other words, the answer to offensive speech is not to cancel or silence the speaker. It is to use your own speech to show why that speech is offensive, to use ridicule or shame or whatever it is, an art of speech. So the answer to offensive speech is not less speech, silence me. It's more speech. You speak back, right? Now you can't do that with threats and abuse, right? Why should you? Why should you? Sometimes you can't do it with threats because the threat is of imminent violence, and the only thing you can do is run away. There isn't time to argue back because somebody's about to thump you, right? And why should you have to spend your time, taking abuse seriously? The answer to abuse, I mean, as I say, I mean, the physical world of pain and suffering is different from the verbal world of words, but we can nonetheless analogize from the one to the other. So I think that threats and abuses are harms, and I do not think that feeling offended is ever a harm which is sufficiently serious to justify criminal or non-criminal action. And the problem with the College of Policing that you mentioned there, Philip, in your question, is not that the College of Policing or not that police officers are using their powers to police criminal speech, but they're using their powers to police what they describe as non-crime hate incidents. And I just don't really understand this. I don't understand what the criminal justice system is doing, spending its precious resources on things which are defined as non-crime. So I think that the way in which we have approached the question of offensive speech or hate speech, as it's sometimes called, is profoundly misguided. profoundly misguided. It's absolutely not what Lucy Connolly was doing. All right. The problem with Lucy Connolly was not that she said something which was offensive. The problem with Lucy Connolly was that she said something which was threatening or abusive, which was intended or reckless as to whether it stirred up racial hatred. And as I said, that's been a criminal offence for a very long time. It's not a new problem. It's not a problem caused by the internet. It's not an OSA problem. But the territory of getting the police or frankly anybody else in the state involved in the policing of speech which other people feel is offensive is a profound mistake.
Okay, let me move that to the a really up-to-date issue at the moment, because I think this week the Labour Party is proposing to bring forward its definition of Islamophobia. And also, they've announced only yesterday that they're going to have what they call a anti-Muslim hostility czar. What's your feeling about that?
Well, I've already answered that question, right? Because I've given you the frame. I haven't seen what their definition is, right?
Yeah,
So,
let me.
for their definition to be compatible with European or indeed our own standards of freedom of expression, any definition of Islamophobia would have to focus on, if it's thinking about criminalizing speech or sanctioning speech, would have to focus on threats and abuse. And if it trespasses over that line into thinking also about offensiveness or things which are shocking or disturbing to some, or indeed things which are blasphemous, then my argument would be that any such definition would be inappropriate and in trouble as far as compatibility with our standards of freedom of expression is concerned. Now, I can't comment on whether the definition does trespass into that territory because I haven't seen it because it's not been published yet. But that's the essential framework to distinguish between threatening and abusive on the one hand, which might very well be the legitimate purview of the criminal law, and speech which is offensive, shocking, or disturbing on the other hand, with which the criminal law should have nothing to do.
Are you in favor of the creation of an Islamophobia definition in principle?
I don't really see why we need it because we already have the offence of using threatening words to stir up religious hatred, and the attractiveness, if that's the right word, of the offence of using threatening words to stir up religious hatred is it applies to all religions. So it applies equally whether you're talking about Jews or Sikhs or Muslims or Protestants or Catholics. Um, and that's the case in both English law and in Scots law. So why we need to take one religion and have additional legal provision with regard to that one religion that isn't shared by others, I'm not sure. I mean, of course, for most of our history, that is what we have done, right? For most of our history, that is what we have done. But the religion that has been particularly protected has been Christianity, and blasphemy was a common law offence until it was abolished by statute not all that long ago. Um, but I would want to see, I think, really quite compelling evidence as to why it was necessary in the public interest for a particular religion to be singled out and given additional safeguards over and above the safeguarding that we already rightly give, I think, to all religions.
Okay, let me give you another case then on this particular theme, because I'd like your view on this. Not so long ago, Hamit Koskan
Yeah,
took himself outside the Turkish consulate or embassy and burnt a copy of the Quran.
yeah.
Was that, in your view, something which is should be legislated against, or should he have the freedom to do that, as the courts have now ruled?
Well, they haven't quite ruled that. So the
Okay.
I've read that case. It's subtle and really important. And Koskin was charged with the offence contrary to Section 5 of the Public Order Act, which is causing harassment, alarm, or distress. Now, there are circumstances in which you can behave that cause a harassment, alarm, or distress. If I was to walk into a mosque with a burning copy of the Quran, or to say that, the Quran should be burnt and whatever, then that would be a very different thing from doing it in my back garden. And these are different poles of extreme, and there will be difficult cases that are at
That,
either end of the pole.
that's
And
almost
what the court
exactly.
ruled in the Koskin case was that in the circumstances of that case, in terms of what he did, when he did it, and where he did it, it was not harassment, alarm, or distress. And so the case has been reported as if it is authority for the proposition that it can never be a criminal offence to burn the Quran, and that's not what the case says.
That's very similar, almost identical answer to what Jonathan Sumption gave me when he said that it depends where you burn the
Yeah.
Quran. But wouldn't you feel that a country should be free enough to be able to burn the Quran in a public place if it so wished to, or a Bible, or a Jewish missal, or something, but just Roman Catholic missal? Wouldn't that be a freer society, or would it be a worse society?
I think it would be a society which is confusing freedom with license. Freedom, properly understood, does not mean the license to behave irrespective of how other people will react to your behavior. Now, sometimes it will be appropriate to act on the crowd, right? Sometimes it will be appropriate to act on the speaker. If I speak in such a way that it is the natural consequences of my actions or my speech that other people are going to be provoked to violence, I don't have the right to do that, whether it's a Quran that I'm burning or a political broadcast that I'm trying to make. And I think that, with freedom, properly understood, comes responsibility. And Jonathan Sumption is entirely right to say that how you speak, where you speak, the manner in which you speak, and here I'm using the burning of a holy book as an example of speech, can make all the difference between criminal liability and the absence of criminal liability. I agree with Jonathan about that.
Isn't this a dangerous principle, though, to say that if it provokes violence, therefore the act should be prevented? I mean, take for example, the burning of the Quran again, compared to the burning of the Bible. If you go into a speaker's corner on a Sunday, which is now something like 90% Muslim speakers, and burnt a copy of the Quran there, you would certainly provoke some kind of negative reaction. But if you went outside a church and burnt a copy of the Bible, people would just pass by and look at you in a sad kind of way. There are some groups of people who are provoked to violence maybe more easily than others are. And aren't you not giving a hostage to fortune here by saying that if it provokes violence, therefore it must be disallowed? And that's damaging to the concept of a free actions in a free country.
It's never been the case. This is not a new problem, right? It's never been the case that our rights, whether they're rights of expression or rights of action, rights of protest, rights to assemble and gather, rights to associate, it's never been the case that those rights can be exercised irregardless of how others may be inspired to react by virtue of what we've said. There is case law I can think of going all the way back to the 1880s about this, the 1880s about this. Um, and I think it's universally understood, even in the United States of America, it's understood. It's certainly understood in European human rights law as well as in the English common law, that public order is a legitimate public interest. And if you act in such a way as to um, provoke violence or disorder, then it might be, depending on the circumstances, and these are often case specific, fact specific cases, it might be, depending on the circumstances, that it is appropriate for the police, even in a liberal country, to intervene on the speaker or the actor or the protester. And there are some people and organizations in the United Kingdom that are really interested at the moment in testing the limits of that, right? Just Stop Oil, test the limits of that.
Yeah.
Extinction Rebellions, test the limits of that. Palestine Action, test the limits of this, right? Then none of these organizations are involved in organizing mass demonstrations with thousands of people, the sorts of demonstrations that I went on when I was a student. Right. What we're now talking about are small numbers of people, often just a dozen or a couple of dozen people, causing disruption to the life of the community. They're not provoking disorder, they're causing disruption. And Parliament has legislated to say, if you cause serious disruption to the life of the community in these kinds of ways, you might be committing quite serious criminal offences. And the courts at the moment are largely upholding police decisions that are being made on the basis of those offences. And this is the cutting edge, right? This is difficult stuff, right? And it depends on it depends. It depends on the circumstances. It depends on the specific facts. But it has never been the case in our legal system that license, individual liberty means license to act irrespective of how others may react to your actions.
Let me give you another case. I saw an interesting video on YouTube, as so many interesting videos are. But there was a guy who was, I think, a Christian preacher preaching for the Bible, who decided he would go and do that in Whitechapel, which is a predominantly Muslim area here, and was confronted by a number of people who were surrounding him and said, "You can't preach that here because this is a Muslim area," and clearly was causing some kind of um, public response, shall we say. Should that be disallowed in this country, that there are certain areas where you can go onto the street and preach, and some areas where you can't?
Um, by and large, I would say no, that shouldn't be allowed. And I think that that was, I remember reading about that case in the press a couple of weeks ago, and I think that was one of the cases where the authorities decided to side with the speaker and not with the crowd. But
Yes.
these are always like these are difficult cases, and there we could look through the law reports, or indeed we could look through the press, and we could find dozens of cases that go in different directions because they are fact sensitive, they're fact specific, and largely and sometimes, not always, but sometimes they depend on the discretion of the police officer who's on the ground at the time. And the police officer on the ground at the time has discretion, right? And the police officer on the ground at the time, the courts will say, should by and large be trusted to exercise that discretion reasonably. Sometimes, of course, police officers on the ground get it wrong. They're too heavy-handed. Sometimes they get it wrong. They're not heavy-handed enough, and they allow violence to result to ensue as a result. I wouldn't want to swap places with them. I think it's an incredibly difficult job to do, right? But there was one case which was reported last year, for example, not reported in the press but reported in the law reports, where an individual protester was on the was outside Southwark Cathedral in London very shortly after the terrorist atrocity just around the corner in Borough Market that had killed a number of people. And he was sitting on the pavement outside Southwark Cathedral, silently protesting with two signs, one of which said, um, uh, "Ban Islam, love Muslims," and the other of which said, "Hate Islam, love Muslims." And the police decided to exercise their discretion by moving him on. They detained him. He wasn't charged with any criminal offense, and so he wasn't convicted of anything. But he argued that his detention, temporary detention, was a disproportionate interference with his rights to public protest, and freedom of expression. And the court sided with the police because they said, look, the sensitivity of the particular place and the particular moment at which this happened, it was just round the corner from Borough Market and it was just after those atrocities, meant that we had to exercise our freedoms more perhaps responsibly than we would otherwise be entitled to do. So this is just an example. I don't know if the court got that one right or wrong, but it's just an example of how time, manner, place can be extraordinarily sensitive, and we should guard against generalizing from the particular, because the courts try very hard in these cases, including in the Koskan case about the Quran burning outside the Turkish consulate, not to lay down general precedents that apply across the piece, because they all understand that these are fact sensitive cases. So, it's difficult to have a conversation about them because we want to generalize. We don't just want to trade anecdotes with one another. That'd be boring. We want to use these anecdotes as if they were data that can lead us to a proposition that we can defend in general terms. And I'm just saying, well, let's caution against that a little bit because, yeah, we can certainly articulate general principles of jurisprudence with regard to freedom of expression. Of course, we can. But when it comes to applying those general principles to particular cases, we need to proceed with some caution.
One can't help feeling, particularly when you're had a few years' experience in the country. I'm 70 years old now. That looking back over my lifetime, I can't help feeling that there's been a significant shift in terms of losing freedoms. I mean, one can't imagine that there would have been these kind of controversies or difficulties back in the 50s or 60s. You could go onto a street and say whatever you like to say, and people would say it's because we're in a free country. But what you've described is a closing in of that kind of freedom.
I don't agree. I don't accept that actually. I mean, in 1960, Penguin Books were prosecuted for publishing Lady Chatterley's Lover.
Different
That
matter,
wouldn't.
though. That's not a that's a publication, isn't it? That's a
It's a free
you,
speech issue. It's an example of the kind of free speech that wasn't very free in the 50s and 60s, the so-called liberal hour of the 50s or 60s, 60s and 70s,
I think
where there was still
Penguin lost.
far more restriction in terms of obscenity and decency, and that's where speech has been liberalized, right? Speech has been very significantly liberalized since those days with regard to obscenity and indecency. It might be that we are more sensitive than we were what's that, sort of 50, 60 years ago, with regard to some of the questions of public order I'm talking about, maybe.
Hmm. Let me move on because there was a number of other things which have happened quite recently. I think only last night or yesterday, the government threw out the idea of limiting 16-year-olds or 16-year-olds and under to have access to social media. Australia has introduced this idea that if you're 16 or under, then you can't have access to social media. We were going along that route, but that's been removed from the legislation. I think the Lords threw it out. No, it's in the House of Commons, I think. So, what's your view on that? Should there be restrictions on social media for under 16s?
I think we've got to let the uh, Online Safety Act do its work, right? The Online Safety Act, it took, I think, 5 years for the Online Safety Act to be made. As we've already discussed in this conversation, Philip, one of the key concerns, one of the key drivers behind the Online Safety Act was child safety online. Um, and the Online Safety Act is now, I think, fully enforced, but has only been fully enforced for a few months. And I think we've got to let it do its work. I mean, I'm not in favor of rushing to re-legislate something which is complicated, subtle, difficult. And as I've already said, it's yielded, not only is the act itself long and complex, but it has also yielded a huge quantity of regulatory guidance and rules and regulations and so on and so forth. So let's just let
Well,
that do its work and then see in a few years' time where we are with it,
Well,
right?
what I'm asking you about is the principle here. And let me rephrase the principle. What about the principle that you need to have declared an identity, your ID, in order to use the internet?
We do that for films. I mean, there's nothing wrong with the principle, right? I mean, we have a British Board of Film Classification that classifies films according to age. So if that's a legitimate way of thinking about distribution of goods and services with regard to expressive power or expressive conduct for film, then why can't it be? Why? I mean, I mean, if there's a question of principle, then in principle it's fine. But I think it's not the only principle in town, right? I mean, I think it's really important that we hold on to the principle that we shouldn't rush to judgment. And we spent a long time on the Online Safety Act. There were six different secretaries of state that helped make the Online Safety Act, working for three different prime ministers. It was as I say, it was a 5 year process. It's only relatively recently come fully into force. Let's see if it works, and
But
let's
there's a
take some
big
time.
difference, though, between film classifications and internet access, particularly so far that if you had to prove um, your age going into a cinema because you're borderline, maybe you could just show a card, and no one would keep any record of that. But online, you have to demonstrate in a much more recordable way that you are over the age of 18. Have an ID system, which then is logging your ID so that you lose anonymity on the internet. That's a different issue, it seems to me. I just wondered what your view is on having no anonymity on the internet.
So it might be that there's some privacy concerns there. It might be that there are some data protection or privacy concerns in and around all of that. I talk to my students about this when I teach this area of the law of freedom of speech in my law school, and I ask them one of the questions I ask them. They're all much more tech savvy than I am. They're all much cleverer than I am. And I said to them, who here has any real idea what kind of digital footprint you're leaving? Do you worry about this? Do you know what cookies are? Do you know, do you read those long screeds that come onto your phone before you can use it that give you essentially one option, I agree, or else you can't use it at all? Of course. So, I think these are real concerns. I think the digital footprint that we're leaving, all of us leave behind on a daily basis. Um, uh, we're all freaked out from time to time when we think that our phone knows more about us than we do. I can be having a conversation one evening with my partner, and the following morning I'm seeing ads on Facebook that seem to reflect that conversation, even though my phone was off during the time, and that freaks us all out. But
Yeah.
um, uh, I'm not sure. I mean, I don't think I understand this area very well. I'm not a privacy lawyer. I'm not a data protection lawyer. I don't know if there's a speech concern with regard to the idea of using age classifications for the reasons I've already given. But there are certainly other civil liberties concerns, and privacy lawyers would know a lot more about that than I do.
Okay. Let me move on to a different area, if I may, and that's human rights laws. Some people are suggesting that human rights laws, and particularly the act of judges, is undermining democratic mandate. Do you go along with that idea or not?
Yeah, it's the very purpose of human rights laws to undermine democratic mandates, right? That's why we have human rights, right? Human rights, democracy is great for majorities, right? If you're part of the majority, then democratic government is tremendous because the point of a democratic government is not to represent the public interest as a whole, but to represent the interests of the majority. But if you are one of the minorities that isn't so well represented by majoritarianism, then we have for a long time recognized that that's one of the roles that law, and in particular that human rights law, can and should play. So, a very good example would be prisoners, right? Particularly in the days when prisoners did not have the right to vote at all. Now, some prisoners do have some rights to vote, but in the days when prisoners did not have the right to vote, it was plainly the case that no MP was going to make much of a political career for him or herself by being the champion of prisoners, right? But we also don't want prisoners to be abused in prison, either by each other or by prison governors, without any recourse to the law. So we have prison law, which is designed to confer various legal rights on prisoners. There are lots of other minorities that we could use as like examples, right? So it is the very purpose of human rights law to remind our constitutional system that there are minority rights which we need to safeguard and protect and think about whilst we're pursuing whatever the majority is voting for at any particular moment. So yeah, it is baked into human rights law that they are counter-majoritarian.
Okay, let me give you one particular case, though, which is very uppermost in society, particularly at the present time, which is the issue of migration. There's quite a large contingent of people who are very much in favour of migration, and there are a very large contingent who are very much against it. The governments and successive governments, right, for the past 14 or 15, 20 years almost, have sought to reduce migration and have promised to do so, but have inevitably failed in that attempt, and they seem to blame the human rights conventions for that failure.
Yeah, it's pathetic, isn't it? Whenever there's low-hanging fruit, the low-hanging fruit is going to be vulnerable to people with sharp words and lousy aim. Even if you accept that immigration is out of control in the United Kingdom, it is completely implausible to pretend that it is out of control because of human rights law. If immigration is out of control in the United Kingdom, it's out of control because we haven't policed our borders properly. Um,
What about
uh,
all the cases which have come up though? Strange cases, you can't deport this person because my child doesn't like the food in a different country, or you
Yeah, but they're
can't.
myths. These cases are largely myths, right? So I've actually studied this. Very recently, since I wrote the book, I've written an article about this, which you can read on the University of Glasgow's website. And the article goes through exactly this issue. You're absolutely right that Parliament has legislated to make it perfectly clear to the courts that deportation is in the public interest in a whole range of cases. And including in cases where people will claim that they have some sort of right to family life or some sort of right to private life, which somehow trumps the public interest in the deportation in their deportation. And the judicial record is overwhelmingly showing that the judges are giving effect to that parliamentary intention and not undermining it. Of course, there are sometimes cases which go the other way, where the individual human right to protection of family or private life is so overwhelming on the facts that it can't be shown to be in the public interest for them to be deported. They're in treatment for cancer, for example, and they're being deported to a place where there are no drugs available for that cancer treatment. Then that's an inhumane thing to do. But that's a very small minority of cases. In the large majority of cases, the overwhelming majority of cases, what Parliament has decreed is in the public interest is what the courts are ruling is in the public interest. So it's a myth that there's any kind of distinction between what the courts want to do and what Parliament wants to do on this. And the reason why I wrote about this is because I read the legal advice that Lord Wolfson compiled for Kemi Badenoch, the leader of the opposition, that led her to the view that it was going to be Conservative Party policy to withdraw from the ECHR. I read that legal advice very carefully. It runs to 150 pages. I've read every word of it. And I went to the cases that he talks about to see whether his analysis of the law was correct or not, because it was different from what my impression was. And when I went to the cases and read them for myself, I saw that he was not accurate in his representation of what the law is requiring. So it is, I'm afraid, a myth. It is untrue that the reason why we have the immigration problems that we have in the United Kingdom is because of human rights law. It's because of a failure on the part of government, not a failure on the part of the judiciary, to police our borders properly.
Is that not the failure to police borders? Is that not a problem of the Human Rights Act? Because
No.
to police your borders properly, for those who are going to say, just that small group that are coming across the channel, Australia just turned those boats back, and then they stopped within a matter of weeks. But I don't think we are able to turn them back or take them back to France because of the Human Rights Act. Is that not the case?
Not as far as I'm aware.
Okay. I just wonder why they're not turning them back then.
So do I.
Oh, okay.
But you know what's the cheaper thing to do? What's the cheaper thing to do? To take pot shots at the judiciary because occasionally you'll find a case that you don't like the outcome of, or to invest properly in a nationwide border force that is capable of policing the border effectively. I know which of those is cheaper, and I know which of those is being done.
Okay, so is there no problem then with activist judges today?
Oh, well, I didn't say that now, did I?
No, I'm just asking. Is there
Of
a
course.
problem with activists?
I think there are. I think right. Yeah. Is there no problem with activists? I mean, that would be a preposterous claim to make. I mean, there is, and again, this is not a new thing. I mean, King James the first thought that his Chief Justice Edward Cook was so activist a judge that he sacked him. Back before the days of security of tenure for the judiciary. Yes, there is always likely to be a problem of activist judges.
Well, that's something you
Is that
disagree
problem
with Jonathan.
manifesting itself in UK law at the moment? By and large, no, it's not. If
That's
you read,
something that you disagree with Jonathan Sumption. He was quite strongly ridiculing the idea that activist judges played any important part in.
well,
Um,
I think I agree with what Jonathan Sumption's written about this. Actually, I mean, I think there have been problems with overly active judges in the UK in the not too distant past, but I think those problems have largely been fixed by a change of personnel and a change of direction in the Supreme Court. If you look at the pages, for example, of the London Review of Books, the London Review of Books is not, I wouldn't say full of, but certainly has published a number of pieces by human rights lawyers arguing that the British courts have become far too conservative. And if there is a problem with the judiciary at the moment, if there's a public relations problem with the judiciary at the moment, it's probably on the other side, right? That the elements of the human rights bar who read organs like the London Review of Books and who write in organs like the London Review of Books are perpetuating myths that the judges have become far too conservative. The European Court of Human Rights is has a more problematic record, I think, with regard to judicial activism than the UK's courts do. But my solution to that would be to reform it, not to withdraw from it. From the outside, we can do nothing to influence it. From the inside, we can and should be doing things to influence the European Court of Human Rights. Although, one of the arguments I make in my book on the law of speaking freely is that in the last 20 years, the European Court of Human Rights has been far too weak at protecting freedom of speech, not far too strong. So they're active in terms of things like climate justice, and quite inactive in terms of protecting freedom of expression.
Okay. Can I move on to a different area and
Mm.
more to do with your own personal experience here, because you're one of the very few people who have been an academic and then given that up almost to become a politician and then come back to being an academic again. And I wonder, what was the single biggest shock that you must have experienced, I suppose, in terms of the difference between how power is really exercised in government, which you've got an example of, that you could never learn, say, from a book?
Um, I wasn't shocked. I wasn't shocked by anything in terms of what I saw in the Scottish Parliament or Scottish government because I had been in and around parliaments and indeed ministers for a long time in an advisory capacity behind the scenes before I went sort of more public. Um, but um, the great unknown, the thing that the public choose to look the other way from when it comes to thinking about the way in which either Scottish politics or British politics works, is the vastness of the cooperation between government and opposition. Um, uh, what we see, because this is what's reported, the fault here is with political journalists, is disagreement, because agreement doesn't sell. Disagreement sells. So we see the cut and thrust of Prime Minister's questions, or we see, the moment where the Prime Minister's on the ropes, whether he's on the ropes because of disagreement with his own side or disagreement with the opposition or whatever it might be. But that is not what politics is really about. What politics is really about, and again, this is a hoary old cliche, but I'm going to use it anyway, is the art of the possible, the art of compromise. And most politics is about deal making, finding agreement with people that come from different political tribes or different political persuasions from where you're at. Most select committee reports in the House of Commons are unanimous, despite the fact that the select committees are comprised of MPs from a variety of different parties and traditions. The same is true in the Scottish Parliament. And so the popular perception of politics as kind of aggressive, um, uh, sort of almost like a form of warfare is almost completely inaccurate.
Did you learn anything from your experience which informs your academic career?
So the thing I most enjoyed about being a politician in comparison with being an academic was the freedom of writing without footnotes. When you're an academic, it's really important that you are able to reference and evidence all of the claims that you make. When you are a politician giving speeches in my case, the Scottish Parliament, you couldn't read out. People would laugh at you if you started reading out footnotes. And that doesn't mean to say that you can make any claim you like and that none of it has to be evidenced. But the way in which you evidence your claims are different. But I found that, notwithstanding the fact that I was very used to public speaking when I went into Parliament, I found that I was incredibly nervous in the first few political speeches I gave because when you lecture students, you're not inviting the students to agree with you, right? You're lecturing students because you're trying to get them to understand something or grapple with a problem, or to see both sides of an argument or whatever it might be. And when you give a speech in Parliament, that's not the purpose of that speech is very different. Or indeed, when you give a political speech in a public meeting, the purpose of that speech is very different from anything that an educator might do. And I found myself getting really, really nervous, which quite surprised me. So it reminded me that the transferable skills may be skills which are transferable, but the purpose for which you're utilizing those skills is very different. So that surprised me. But what I enjoyed most about politics was the fact that you can't do anything by yourself. Anything that you try and achieve in politics, whether it's an amendment to a bill, such as the example I gave you earlier of making the test for stirring up offences objective rather than subjective, you're going to be successful only if you can get a lot of people to agree with you, and a lot of people who would disagree with you on a whole range of other issues to agree with you on this issue. Whereas, um, for most of us who work in the academy, at least on the arts side, on the humanities side, it's different for scientists who are running big labs. We work on our own. My academic endeavors are sort of monkish. I sit on my own, either in a library or in my office, and I read books quietly and I write books quietly. The core of the enterprise, obviously, teaching is not as a lonely activity, but the core of the enterprise, the core of academic research for arts and humanities professors, anyway, is lonely. Whereas you literally cannot do anything by yourself in politics.
You've advised the House of Lords committees there, and you've advised the Scotland office. The government depends to a large extent on legal advice, and particularly Keir Starmer's government has taken a lot of legal advice, particularly from the Attorney General, Lord Hermer, and
Yeah,
people have criticised that advice, particularly with regard to things like his advice on the Chagos
there you go. Yeah.
Islands and other areas. What do you make of the advice which has been given, say, about the Chagos Islands? Is that is that something you had an opinion on?
I,
Because I've not been able to understand it myself as a
I
someone who's done.
Chagos, I worry. I worry about whether um, some of the opinions that have been offered in international law haven't been misinterpreted by government lawyers as something which is a little bit harder than an opinion. And I think that grave injustice, I know that grave injustice, really shocking injustice was done to the Chagossians
Mm,
in the 1960s.
yeah.
And I would be much more sympathetic to an argument that that injustice should be remedied than I would be to any argument that the Chagos Islands are somehow part of Mauritius or would be better off if they were subject to Mauritian sovereignty than if they were subject to British sovereignty.
Does it make any
They're
sense to you the way in
1,300,
which?
the Chagos Islands are 1,300 miles away from
Yeah,
Mauritius. Now,
I
they're
know.
a lot further than that away from us, of course, but the Chagossians, certainly when they were exiled by the Brits in the 1960s and 70s, did not want to be Mauritian. They did not want to be in Mauritius. So I think that the whole focus of the Chagos argument is completely misplaced, and the focus ought to be on trying to remedy the injustice that those people suffered at our hands a generation or two ago, rather than worrying about what an opinion of an international court might be about the future of Mauritian sovereignty.
So does it make any sense to you why the Starmer government has been pushing for this quite strongly, hugely, very strongly against American advice, against other people's advice, against what others would say is simple common sense? But never mind the.
I think that you can find instances where uh, um, legal opinions are taken too seriously. Now, I believe in the rule of law. I believe that governments should adhere to legal obligations and requirements. But I also think that sometimes the opinions that are reached, and I keep using this word opinions that are reached by international lawyers should not be taken as gospel. They should be taken as useful, helpful interventions in an ongoing political or geopolitical conversation about what the appropriate thing to do is in the name of justice for the Chagossian people.
What
Um,
about the advice for in the recent Iran war, where it seems that Starmer had taken advice that he shouldn't allow the Americans to use our own RAF bases for launching attacks? That was advice given to him by lawyers, apparently.
yeah, I was talking to an international law colleague about this just yesterday. and we were comparing the last fortnight with those tortuous months in the lead up to the Gulf War, where um, Jack Straw and Colin Powell and others were desperately trying to get UN Security Council resolutions that justified the use of force or authorized the use of force in Iraq, and how different that environment was from the environment that we're in at the moment. And the question is this: which does more damage to the international rule of law? Going in without even trying to go through the UN, without even trying to go through the Security Council, which is what Trump and Netanyahu have just done in Iran, or trying to go through that route but failing and going into Iraq anyway, which is more or less what happened in the Gulf War 20 years ago, or whenever it was. Um, uh, and I don't know if any of us yet know what the answer to that question might be.
What's your view of the way in which the government has managed a whole range of U-turns over the past, year that it's been in power or so? Has it been the subject of rather poor advice, or what's the cause of
Poor,
such a?
poor planning, perhaps, and a lack of political control at the center, right? I mean, everybody in politics, whether they are friends of his or opponents of his, or indeed enemies of his. And of course, the opponents are the people who sit opposite you in the House of Commons, and the enemies are the people who sit behind you in the House of Commons, as we all know. But whether we're talking about friends of the Prime Minister, opponents of the Prime Minister, or enemies of the Prime Minister, the one thing that unites them all about the Prime Minister is he's not a very good politician. He's a very good lawyer. He is a very, very good lawyer. He's a very interesting lawyer in Parliament, right? A very interesting lawyer in politics. But he doesn't have highly tuned political antenna. And he doesn't have a political grip on what he wants his government to deliver politically, either for the Labour Party or for the country. I'm sure it's not true that he bears the impression of anybody whoever last sat on him. I'm sure that would be an injustice. But you can see why somebody with so poor a set of political skills is struggling to appear consistent or even all that leaderly, if that's a word, um, when there are so many different competing tensions that you have to wrestle with when you're occupying an office such as Prime Minister of the United Kingdom. Um, uh, so I think that what we see in these kind of this apparently endless uh, stream of U-turns and indecision is the consequence of a very unusual government, right? It's been quite a long time since we've had a government which has been led by somebody with so um, incomplete a set of political skills as this.
With it? Adam, we're reaching the end of our time together, and I just had one last question, if I may. It might be a difficult question, though, but considering the times in which we live and the problems that we particularly have, a highly polarized society and declining trust in institutions and such like, are there any changes which, if you were in government now, you would want to make? Any constitutional changes which would help to set the course on a more even keel for the future and prevent some of these problems occurring? What would you like to see in place?
So my answer would be different depending on whether we're talking about the UK or Scotland, right? So at Scottish level, right, what we absolutely need in the Scottish Parliament is a parliament that does the job of holding the government to account much better than the Scottish Parliament has ever done, right? So the Scottish Parliament is actually quite a good legislator, right? Most of the legislative output of the Scottish Parliament is, I would say, superior to the legislative output of the House of Commons. The legislative output of the House of Commons routinely has to be checked and corrected by the House of Lords. The House of Lords is a really good legislator. The House of Commons, however, is really good at holding the government to account. It spends quite a lot of time and resource on doing that. So, the one change I would make in Scotland would be that we need a Scottish Parliament that is as determined to hold the government to account as it is determined to make good law for the people of Scotland. And at UK level, I think that where we've gone wrong at UK level uh, is over privileging democratic mandates at the expense of what you might call aristocratic or elite checks on democracy, right? So the House of Lords both as a second chamber and indeed as the old highest court, the Appellate Committee of the House of Lords. Now that jurisdiction is transferred, of course, to the Supreme Court, used to be much more respected, not just by the public, but by the public's elected representatives than they are now. And the relationship between the House of Commons and the House of Lords has gone out of kilter in favour of the Commons, and that has been a mistake. So I disagree with those people who think that we need to see House of Lords reform. I think we need to see House of Commons reform, and we need to see a
I
House of
think
Lords which is more self-confident and better able to articulate why its constitutional job is to check the House of Commons
we've
and
just
not the
lost
other
the
way around.
hereditary peers, I believe, only was it yesterday?
Sorry?
We've just lost the hereditary peers. Uh,
Yes, that may be case. I haven't read the news in the last couple of days, but that certainly has been coming. And again, I think that's a mistake. I think it's a mistake continually to downgrade and undermine the authority of non-democratic checks on the demos, right? Now, I'm a Democrat. I don't want undemocratic government. I want democratic government. But I know that, the people who best understood how to write constitutions and how to balance constitutions knew and understood that they had to balance democratic impulses with counter-majoritarian institutions and checks and balances. Checks and balances is Madison's phrase from Federalist 51, 1789. Madison was right in 1789, and he's still right now. Right? We need a constitution in order to have constitutional stability, in order to have good, sound, proper constitutional government. We need, of course, a democratic government, but a government which is at the same time checked and balanced by um, institutions which obtain their authority not from majority rule, but from merit or trust. And those institutions include the House of Lords and the Supreme Court.
would you go so far as to seek to duplicate a written constitution in the form that America has one, or is that a step too far?
No, I mean written constitutions. It's just, I mean, it's just idle to speculate about written constitutions in the context of any of the countries that don't have them, Britain, Israel, or New Zealand being the leading examples. Because written constitutions happen for particular reasons and at particular moments in countries' histories. They happen because of a gaining of independence from a colonial era, or they happen because of defeat in war, Germany 1945, or they happen because of revolution, France 1790 or America. And unless and until the United Kingdom experiences any of those phenomena, it's not going to get a written constitution. So it's just idle. I mean, written constitutions don't just happen when a country decides that it would be nice to have one. This is what Charter 88 and the other kind of, very
But
well-meaning, but
but they do place limitations on the demos. I mean, the First Amendment of the American
yeah, I
Constitution.
know. Yeah, I know. I mean, but so does our constitution. Our constitution, properly understood, our constitutional order, notwithstanding the fact that it's not codified in a single document, imposes limitations on the demos as it should. You don't need a written constitution to do that, and we're not going to get a written constitution anytime soon.
Fair enough. Adam Tompkins, thank you very much indeed for your time today and for a
Thank you
fascinating
so much.
conversation.
It's been a
Thank you.
pleasure. Thank you.